we simply don't have the power to entertain this doctrine in this court, in this country. Maybe in a different country, fine. Maybe if we did not have the self-imposed limitation in Article 1, Clause 1, fine. But unless and until we change Article 1, Clause 1, whereby we permit ourselves to exercise our sovereignty in a manner not in accordance with this Constitution, until that day, we cannot entertain this doctrine in Kenya. Now, some might say, now, when Aluochier, if you're speaking this way, you probably brought reggae back into business. Reggae was a tough time. Somebody will say, now you're actually pleasing President Uhuru Kenyatta because he has been saying in all of any function he has, this thing is coming back, this thing is coming back. I am not necessarily saying so. What I am saying is that the basic structure doctrine is a legal device that has been used by the courts in an effort to promote democracy. If you look at the words in the judgment of Patrick Kiage, Justice in the Court of Appeal, he said he was using the basic structure doctrine as a defense mechanism for the Constitution. He cannot stomach anybody trying to rubbish and dismember this Constitution, and therefore he's using the basic structure doctrine as a defense shield or a mechanism to defend this Constitution. But then Article 1, Clause 1 says very clearly, our sovereignty is to be exercised only in accordance with this Constitution. Your authority as judges is limited to our sovereign authority. And since we have limited the manner we exercise our sovereignty to only in accordance with this Constitution, you cannot go beyond that. You cannot use extra constitutional measures, even in an effort to defend this Constitution of ours. You are confined only to using legally and constitutionally permitted defense mechanisms and not go beyond what is permitted.